The labyrinthine legal saga surrounding Ghislaine Maxwell continues to captivate, offering a chilling glimpse into the dark underbelly of power and exploitation. Her conviction was a landmark, yet the true extent of the Epstein network remains shrouded in speculation and legal maneuvering. We dissect the intricate layers of her case, from the courtroom battles to the tantalizing prospect of future revelations. Ghislaine Maxwell's conviction in December 2021 marked a pivotal moment in the pursuit of justice for Jeffrey Epstein's victims. Found guilty of sex trafficking and conspiracy, she was unequivocally identified as a key enabler in a horrific scheme. This verdict was not merely a conviction, it was a judicial affirmation of the systemic abuse perpetrated by Epstein and his accomplices. Her subsequent sentencing to 20 years in prison underscored the gravity of her crimes. This substantial term reflected the court's recognition of her deep complicity and the profound harm inflicted upon countless young lives. For legal observers, it was a testament to the perseverance of prosecutors and the courage of survivors. The trial itself served as a harrowing exposé, meticulously detailing the mechanics of Epstein's predatory enterprise. Witness after witness bravely recounted their experiences, painting a grim picture of sexual exploitation at various Epstein properties. These testimonies were not just personal narratives, they were crucial pieces of evidence, meticulously corroborated to establish a pattern of abuse. Maxwell's role, as proven in court, was far from passive. She was convicted of actively luring and grooming teenage girls, facilitating their sexual abuse by Epstein. The prosecution successfully argued that Maxwell and Epstein operated as a cohesive unit, deliberately constructing a network of underage victims. This legal finding solidified her position as an indispensable architect of the abuse. In a dramatic turn, Ghislaine Maxwell offered to testify before Congress in July 2025, but with a series of highly specific and legally significant demands. Her primary condition was formal immunity, a shield against further prosecution for any information she might disclose. This request immediately raised red flags for legal analysts. Her additional stipulations: that the interview not occur at the correctional facility, that questions be provided in advance, and that the deposition await the resolution of her Supreme Court and habeas petitions revealed a calculated legal strategy. These demands aim to maximize her control over the narrative and minimize her legal exposure. The House Oversight Committee's swift refusal to grant congressional immunity highlighted the inherent conflict between seeking truth and protecting a convicted felon. The persistent speculation surrounding a potential client list has been a central theme in the Epstein saga. Many legal experts believe Maxwell possesses intimate knowledge of Epstein's associates, suggesting she knows everything about his illicit network. This belief fuels the hope that her testimony could finally expose the full extent of complicity among powerful individuals. However, the legal reality of compelling such a list is complex. Even if Maxwell were to cooperate, the information would need to be verifiable and admissible in court. The concept of a client list often conjures images of a neatly compiled ledger, but the reality is likely far more fragmented and challenging to prove. The pursuit of this list remains a significant investigative objective. Any potential testimony from Ghislaine Maxwell faces a formidable hurdle: her documented history of lying under oath. Her past denials regarding Epstein's trafficking and her own involvement have severely compromised her credibility as a witness. This pattern of perjury raises serious questions about the reliability of any future statements she might make. In legal proceedings, a witness's credibility is paramount. A history of dishonesty can lead to their testimony being discounted or viewed with extreme skepticism. While Maxwell might possess valuable information, her past conduct means that any disclosures would require rigorous, independent corroboration. This challenge complicates the investigative utility of her potential cooperation. Maxwell's motivations for offering testimony are subject to intense scrutiny. With a 20-year sentence already imposed, it's unclear what tangible benefit she seeks from cooperation. Legal experts suggest that if she were to sign a cooperation agreement, prosecutors could potentially request a resentencing, offering a glimmer of hope for a reduced term. This remains her most significant leverage. However, the decision to cooperate is a complex one fraught with risks. Revealing information could expose her to further legal jeopardy or endanger her safety. The calculus for a convicted felon in her position involves weighing the potential for a reduced sentence against the dangers of full disclosure. Her current demands suggest a desire to control the terms of any such agreement. The unsealing of court documents in January 2024 related to a 2015 lawsuit against Maxwell provided a chilling confirmation of the scale of Epstein's alleged sex trafficking ring. These documents offered an unprecedented glimpse into his powerful social network, revealing names previously only whispered in speculation. The public release of these records was a significant victory for transparency. The documents mentioned numerous individuals associated with Epstein, including prominent figures like Prince Andrew, Bill Clinton, and Donald Trump. While mere mention does not imply guilt, it highlighted the extensive reach of Epstein's connections. For true crime enthusiasts, these unsealed files were a treasure trove of investigative leads, further fueling the demand for accountability. Maxwell's lawyer has explicitly stated her intention to plead the Fifth Amendment at any deposition unless she is granted immunity or receives a presidential pardon. This declaration underscores the high stakes involved in her potential testimony. Immunity would legally protect her from prosecution for the information she provides, while a pardon would completely absolve her of federal crimes. The prospect of a pardon, particularly from a former president, has been met with fierce opposition from victims' families. Virginia Giuffre's family members have vociferously argued against any leniency for Maxwell, emphasizing the need for her to serve her full sentence. The debate over immunity and pardon highlights the tension between the pursuit of truth and the demands of justice for victims. Whether Ghislaine Maxwell's testimony will truly expose the full depth of the Epstein network remains an open question. Her willingness to cooperate is contingent on highly specific demands, and her credibility as a witness is undeniably compromised. The unsealed documents and her trial have shed significant light on the network's operations, but many secrets may still be hidden within the shadows. The legal and investigative community continues to press for answers, driven by the imperative to hold all complicit parties accountable. The pursuit of justice for Epstein's victims is far from over, and every legal maneuver, every unsealed document, brings us closer to understanding the full scope of this horrific enterprise. Join the conversation and share your insights on this complex legal saga. What do you believe Maxwell truly knows? How should the legal system balance the pursuit of truth with the demands of justice? Leave your comments below, subscribe for more in-depth legal analysis, and help us continue to shine a light on these critical issues.